Can't hear you at all, Norm.
And of course, Mike can't hear me at all, so I don't know.
Your volume is very, very, very low.
Well, I don't know what's going on there. You can do is I can switch over to the computer and do it that way. We were having issues.
This is so on brand for us.
Yeah. Can you hear me now? Is it the tin can syndrome?
There we go.
Or to the computer, the sound quality must SUCK.
You sound great now.
Well, I have no idea what's going on with, I'm trying very hard to get and I have purchased a new Focusrite system and I'm trying to get it all worked in our testing this morning and it didn't work now, but that's life. Let's move on. There's a whole world out there and this the best of all possible worlds. The week before Thanksgiving, the stuffing day, and I'm referring to all the stuffing we do to ourselves. And then the comatose afternoons in front of the television looking at college football. Yes, that's Thanksgiving. That's why people crossed the seas. That's why we established a city on a hill so that we could eat ourselves silly and root for the Detroit Lions, who this year seem to have something to root for. Anyhow, lots going on in the world. I don't even know where to start. I guess I'll pat Mike and I on the back and break my arm. Thank you to the New York Appellate Court. Judge Engoron's gag order on Trump was lifted. An associate justice of the appellate division in the New York Court of Appeals said, hey, wait a minute, there's something wrong here. Well, of course there's something wrong here. Judge Engoron doesn't get to protect his co-judicial girlfriend on the bench, Miss Greenfield, from criticism. He put her up there, sat him next to her, whispers tender blandishments in his ear while everybody's watching and everybody's thinking, hey, who's the fat chick sitting next to Jack Spratt?
Did you just say tender blandishments?
Yeah.
Keep going.
No, but I mean, it's just a bad look. And for the judge to say, I'm going to issue a gag order, neither the president nor his men and women, his lawyers, his counsel can comment on court staff. There's just no such thing in American law, nor ever has there been, for a gag rule on that basis. A gag rule goes to affect fair trial rights of the defendant, or the rights actually, there are no fair trial rights in the Constitution for the government. The Sixth Amendment is directed to defendants, not to the government. But the courts assert a power over the administration of justice, and that power gives them broad discretion to assure fair procedures. And courts have experimented with gag orders in that regard. Engoron did in this case. I think he went too far in violation of the First Amendment. The First Amendment places limits on all branches of government, including the judicial branch. And so while Engoron may believe he has valid grounds to think the administration of justice requires a gag order, the First Amendment says, no, Judge Knucklehead, you can't do that. And neither can your co-judge, semi-judge, Judge Greenfield, sitting up there on the bench. So good news, the stay is obviously not a permanent ruling, but what that means is that when Trump's lawyers filed their paperwork in the appellate court and asked for a stay, the court had to make an evaluation of a substantial.
Uh-oh, your audio went out again. Norm, can you hear me? Hello? Chat, can anybody hear Norm? Can't hear you, Norm. Unmute your mic. Unmute your mic. Just right here on the all right, we'll get him back. In the browser there. No, look at the window here in StreamYard. You're just click the little mute button. The microphone button. This is honestly one of the most endearing things to me. He'll be right back. And we'll be doing AMA today as well. So While he comes back in, I'll just throw this banner up here. Here he comes. There he is.
Yeah, I don't know what's going on. My ability, somebody with some technological sophistication help Mike and me, or at least me, because I went out.
Well, Mike, I mean, this is you've got to own partially my failure. You've chosen to affiliate with me. And
I just think it's part of our brand now. I'm not even worried about it.
Well, I'm worried about it. So where was I prattling when the gods cut me off?
You were talking about Judge Engoron protecting himself and his courtroom.
Yeah. So, and that he may have thought that was something necessary to do to protect the administration of justice, and that is a core power, an inherent power that the judicial branch has. But the judicial branch's inherent power stubs its toe against the absolute bar that the First Amendment places on prohibitions against against gag orders, frankly. And so there is no case law that suggests that a court can gag a trial participant because the trial participant is picking on the judge's clerk or mini co-judge. And anybody who suggests otherwise is simply wrong. Now, people may point to a ruling in Connecticut in the Alex Jones case, where the Connecticut Supreme Court applied its inherent supervisory power to deprive Alex Jones of hearing, having heard a motion, an anti-SLAPP motion to dismiss. We took an appeal of that, an emergency appeal to the Connecticut Supreme Court, arguing that the Connecticut Supreme Court and Judge Bellis ignored the First Amendment prohibition. The Supreme Court ignored the First Amendment argument. Connecticut Supreme Court, we filed a writ of certiorari to the United States Supreme Court. They declined to hear it, proving yet once again that if you're Alex Jones, the quality of justice you get is watered down by the great sympathy that fact finders have in both judicial and jury for victims of the Sandy Hook massacre, much to the shame of the American judicial system, in my view. And this ruling should find its way to Judge Chutkan's desk. Because Jack Smith is making similar claims in Washington state. His staff, his family, he himself feels discomfited by Trump's attacks. There are other vehicles that can be taken to silence Trump, including lawsuits and so forth. But for the court to claim that we have the inherent authority to trump no pun intended, the First Amendment and to issue a gag order is a chilling assertion of judicial power that no one who cares about individual rights and individual liberties should let pass.
Hey, Norm, a couple of things here on this topic in particular. A.R. Hoffman is who wrote this article for the New York Sun. I do commend that to any of our viewers and listeners. The title of the article from the New York Sun today is "Trump's Free Speech Win Puts Gag Order on Hold, temporarily at least, and Tees Up a Constitutional Clash." I wanted to note one thing here at the end of the article, and the reason I point out A.R. Hoffman, he is actually he has a PhD from Harvard and a law degree from Stanford, Norm. So it's rare to have someone writing on issues of legal import that also have a law degree, let alone a law degree from Stanford. So good for you, A.R. Hoffman. He says, quote, "The former president has found some unexpected allies in his efforts to resist gag orders. The American Civil Liberties Union, the ACLU, a liberal lodestar, argues in a brief to Judge Chutkan that her order, quote, fails to provide the fair warning that a constitution demands because Mr. Trump cannot possibly know what he is permitted to say and what he is not," which is absolutely correct. He goes on to say the dean of the University of California, Berkeley School of Law, Erwin Chemerinsky, concurs. In Los Angeles Times, Mr. Chemerinsky writes that while he, quote, often wishes that Donald Trump would shut up, he has a constitutional right to not to. End quote. The constitutional sage explains that, quote, unpleasant and offensive communication is simply not a basis for restricting speech under the First Amendment.
Hear, hear, Professor Chemerinsky or Dean Chemerinsky. Well said and well taken, and we look forward to the litigation of these claims. Let's pivot quickly. Did any of our listeners in New York City or connected with New York Legal Aid? If so, send a note to one of your colleagues or to a legal aid employee named Nikita Raina. Nikekaraina. Nikita, get a new job. Nikita Raina is a member of the Legal Aid Society that provides legal services to the indigent in New York City. They do God's work. And they often attract radical lawyers with a commitment to social change. That's fine. You can have a commitment to social change. You can be a hidebound conservative. You can be a curmudgeon, as Mike and I are, or at least I am, and I think Mike aspires to be. He doesn't quite have enough gray hairs or any gray hairs yet to win the.
I'm lucky to have hair. I'm lucky to have hair. That'll turn gray.
Yeah, I did notice that. Well, what is that? What is that on the top of your head? Oh, it's your skull.
Yeah,
but listen to Nikita. This is in an email she sent to her colleagues, as reported in the New York Post this morning. Being a public defender should inherently mean you're against effing genocide. But I guess legal aid is so desperate for attorneys, the organization just lets anyone these days stay. Oof. You dumb F genocide supporters. And this is the part that gets me. The United States and Israel are both settler colonial entities, and both shouldn't fucking exist, you dipshits. Excuse me, I didn't censor that. Both shouldn't effing exist, you dip S's. This is Nikita Reyna talking, an officer of the court, a person who's presumably gone to law school, passed the bar, and sworn an oath to protect, uphold, and defend the United States Constitution. And she's telling her fellow lawyers the United States shouldn't exist because we're both settler colonial entities and yada, yada, yada. I mean, I don't know what kind of name Nikita Reyna is. It doesn't sound Lakota or Chippewa. I suspect Nikita, like most of us, came here from elsewhere and threw her lot in with other strangers to try to determine how best to have a good life under the rule of law. Nikita, history is written in tears, in ink that is inspired by tears, and we've all shed them. We shed them for ourselves and for one another. It's called the legacy of sin. For you to hop on your self-righteous bandwagon and berate your colleagues and suggest that you, as an officer of the court, are supporting a regime that shouldn't exist, in my opinion, calls into question your fitness to practice law. Now, Mike has pulled up, I gather, a LinkedIn page or something that says
she's embedded within the New York Post article.
Okay, she's a JD candidate. That's at odds with that must be an older image because the Post reports that she's currently a lawyer. Somebody pull Nikita aside and give her a talk about what the rule of law means and what her obligations are as an officer of the court. She can support Hamas. That's fine. That's her right. I can ridicule her for supporting Hamas. That's fine. That's my right. But what neither of us can do as officers of the court is seek to undermine the institutions we've sworn a duty to uphold, even as our society around us crumbles. So a dart to Nikita today. Somebody give her a good smacking upside the head and say, woman, what you thinking? Or are you thinking at all?
What's up with you white women?
Well, is she a white woman? I mean, what is white these days? Nikita, what do you identify as? I could tell you what you look like, but I don't want to get in trouble with the bar myself. Hey, what's up with Vivek Ramaswamy and digital assets? This is an interesting discussion, and it's off the Palestine topic, which is a great topic to be off of these days.
Yeah, well, number one, what's up with Vivek? He's just out here crushing, per usual. What I put on the screen, however, is from his account yesterday, and he posted, quote, digital assets shouldn't be subject to the arbitrary and capricious regulatory whims of the SEC and the Federal Reserve. Despite little formal mandate from Congress, these agencies have made themselves key gatekeepers for innovation and leverage ambiguity to suppress it. It is not the role of the federal agencies to make qualitative judgments about the merit of an entire industry or technology. And he goes on to put 3 bullet points here, Norm. Consistent with West Virginia v. EPA, require regulators to restrict themselves to precise statutory provisions and apply subsequent rules within constitutional confines. The second one says, create a process across the SEC and CFTC for new digital assets where they enjoy a short period of safe harbor and then are programmatically classified into securities or commodities. Number 3, the Federal Reserve should grant stablecoin issuers the same access to Fed facilities that incumbent banks enjoy so they can create safe and liquid products to further expand dollar hegemony. So I think that this is interesting. I don't want to play the whole 3-minute segment here, but it's essentially the essence of what he says in the video. He has, kind of summarized for us here on the screen in his post, and the quality of the audio of the video is a little bit abrasive, so I don't want to subject everybody to that. But I wanted to talk about this for a couple of reasons. One, Jimmy Valley is, a frequent guest here on the podcast, friend, and he is of Val Hill Capital and works within the XRP and the Ripple technology framework. And I think I come at these issues from a perspective because we've had Jimmy Valley on so often to say, what would Jimmy say in this instance? How would he view these opinions? And in particular, I think that second bullet point, Norm, Vivek is saying that we need to create a process by which these coins would enjoy some sort of safe harbor and then be programmatically classified into either an investment contract, right, a security, or a commodity, which does not need to observe the same level of scrutiny that is currently being applied, or was at least attempting to be applied, to Ripple and XRP buying through their lawsuit with the SEC right now.
So, can you hear me right now, Mike?
I can, yeah.
Switch back to mics. I wanted to make sure. I can't help but wonder whether Vivek's comments here are like 5 years too late. Because I understand where he's coming from, and one of the things I appreciate most about him is his skepticism about the efficacy of government in general to provide a good life. I think Vivek would agree with the proposition that one of the geniuses of American politics is that it leaves to us, we the people, the right to chart our own course, and that government is a gatekeeper that sets limits on extremes, as it were. It regulates in the name of public safety, in the name of the public good, but not regulates in and of itself. And what he's pointing to here is problems with the so-called administrative state, what in the 1930s and 40s was called the non-delegation doctrine. And I'm going to nerd out for a moment on constitutional law for you non-lawyers. Our government, our federal government, is composed of three branches: the judiciary, the federal, the legislature, and the executive branch. And those are the three branches of government. They're equal and coordinate. They don't have equal powers, but they are coordinate, and each is supposed to check and balance the others. In other words, we've baked in to the American government internal checks and balances such that it's never going to be efficient. And so when people complain that government's inefficient, I'm like, well, hello, yeah, and Thanksgiving turkey is filling, some things are just true. So it's supposed to be that way. But where do administrative agencies fit in? If you think about it, there is no fourth branch of government. The regulatory state gives to regulatory agencies the ability to regulate activities, presumably in the common good. And they do so by way of congressional delegations of power. So when Congress delegates a power to regulate securities, let's say, it will give the SEC a definition of securities and then set the SEC loose to enforce that through appropriate means. I think what Vivek is saying is that the administrative agencies, in their rule-making capacity, that is, their capacity to make rules to fulfill the purposes that Congress has delegated to them, often exceed that and become, in effect, lawmakers themselves in administrative overreach. They take power over.
Here we go again. We just lost you again, Norm. Just lost you again, Norm. Can't hear you. Cannot hear you. All right, now hit that button. This is at least this is live and we can see the struggle. Yeah, you need to unmute your mic right there. Unmute your mic in StreamYard. Unmute the mic in StreamYard since you've switched the input. Adding you back to the stage. Just unmute your mic. All right, he'll be back. On brand. How is everybody with this beautiful Friday morning? We'll have to remind Norm of where he was in that sort of constitutional analysis. But my point with this was mostly, and here he comes. Hey.
Can you hear me now?
Yeah.
Can you hear me now?
Yeah, I can hear you, but it's going to be kind of messed up. Can you hear me? Just don't use that mic anymore. Use the computer mic.
Can you hear me now?
Yep. We can hear you now. Yes. I can hear you. Hello.
Can you hear me?
Yes, I can hear you. Yeah, but you're in and out. Use your computer mic.
Can you hear me now?
Yes, we can hear you. We got you.
I just had to unplug the audio thing I was working on, just use the computer here.
Yep.
So what I was trying to say when you were waving at me that sound cut out was that the controversy over the non-delegation doctrine had to do with the following. Congress would delegate power to agencies to accomplish things like regulate agriculture, let's say, and then agencies would come up with things that were arguably well beyond the congressional grant, or others argued they had no power at all, these agencies, because they were a headless fourth branch of government. Congress could not delegate its lawmaking function and change it into something else simply by calling it rulemaking. The courts upheld these broad delegations of power, and there is now a pushback in the federal courts. And so the West Virginia versus EPA decision is one instance of it. There are other cases, typically involving the EPA, involving groundwater and whatnot, where the claim is that the agencies take a general power and grant and use particular applications of it well in excess of what Congress had intended. And I think that's what Vivek is saying as to the SEC insofar as its regulation of cryptocurrencies are concerned. But I think in defense of the SEC's position, what they're saying is cryptocurrencies have enough in common with the congressional definition of a security that they ought to be regulated. And thus in the Ripple litigation, Ripple pushed back and said, no, it doesn't. And so this is what makes cases get to the United States Supreme Court.
There's some additional context there, though, right, Norm? Because I think one thing that we've learned about Vivek is, and what we've heard as well from Jimmy Valley, is the corruption inherent in the SEC, or at least the appearance of impropriety and some sort of favoritism within the decision making of the SEC to prosecute certain cases versus let certain other players in the same exact industry go unfettered or unmanaged, right? And so what this highlights is his appeal to sort of the constitutional framework for the regulatory authority, West Virginia v. EPA, and in terms of them looking for a strict reading of a statute that would authorize that regulatory agency to coerce certain conduct or regulate an industry in a certain way, is necessarily to say you need to treat everybody the same. Whatever you're doing, we haven't even crossed the threshold of you treating everybody the same. Not only do we know that the SEC is not necessarily as adept at understanding what these technologies are, which is why I like the short period of safe harbor. I don't know what that means from a consumer perspective. I think that's particularly dangerous because we know that all of the SEC regulations are designed in, well, from my perspective as a practitioner, the way that I would explain it is that this is a consumer protection agency at bottom, right? What the government wants to do here is ensure that the average civilian who might not be a sophisticated investor is not led to invest their own hard-earned money into something that is a scam or is untrustworthy or is otherwise likely to fail them, right? But how do we know that? So I don't know what it means in terms of a short safe harbor for this stuff, because people are treating cryptocurrencies and digital assets like stores of value, and they're looking for ways. Jimmy Valley has talked about this. They're looking for ways to transact across networks and across sovereign boundaries, right? They're trying to make an exchange of goods and services that ultimately is not really underwritten by the fiat US dollar. Right?
No, and I get that. And that poses a challenge to the state, obviously, and to the very notion of a currency and what a currency is supposed to do. I mean, it's a store of value. It's a medium of exchange. And obviously, you want to inspire confidence in it, in those functions, so that commerce can continue. A crypto entity that challenges fiat currency, that is dollars and cents, as it were, it poses a direct threat to the hegemony, the control of the dollar or of fiat currency in a marketplace. And that may or may not be a good thing. I mean, early on, cryptocurrency was criticized as being a safe harbor for criminals. You recall the dark web, and I can't remember the fellow's name, that he ended up getting so much time because he was using the dark web to sell drugs, guns, and sex and everything else. But I think that where I'm a little bit skeptical of Ramaswamy, preaching to preaching to the cheap seats in the ballpark, is it's a little too easy to adopt the old non-delegation type of arguments and say the agencies have overreached, or it's a little too easy to say, well, they are corrupt in their application of the problem. The corruption problem is really just an institutional failure that can be corrected on an ad hoc basis. The more interesting issue to me is the classification problem, which is to say, how do we know who gets to decide what a currency or what a security is as new products enter the market? And isn't that really the function of the SEC? Now, if somebody thinks the SEC is overreached and given an overbroad application of it, you go to the courts. And you end up with cases like West Virginia versus EPA. So I'm not sure what Vivek means when he's calling for a safe harbor. I mean, we've had cryptocurrencies in the market now for 15, 20 years. And I think the SEC was very slow to react to what cryptocurrencies are, and maybe clumsy in its reaction. But it seems to me that the more cogent response to this problem would be a call for Congress to legislate and simply say to the SEC, we declare that cryptocurrencies are or are not securities. But I don't fault the SEC for struggling with the issue, because if it's going to regulate a security, it first has to identify what a security is. And let's face it, in a market, people are always testing the edges. So there'll be things that come right up to the edge of the current definition of a security, but aren't quite. And there'll be things that go one step further and do become a security. And that's always going to look like an arbitrary line from the outside. But in terms of administrative enforcement, what else can we expect?
Well, and so Don asks, what's happening with the FCC and control of the internet by federal government, seeing things on X about this. So Norm, I'm going to make an on-the-spot pivot to what we can agree is a credible account on X, Larry Elder. And so he has posted an article from the Daily Signal that says Biden's plan for internet infrastructure, sweeping FCC regulatory command and control. Quote, those rules would give the federal government a roving mandate to micromanage nearly every aspect of how the internet functions. And this is brand new. I think this was being voted on yesterday. But ultimately, if we're talking about cryptocurrency and digital assets, Norm, that all functions atop the internet, right?
No, I think that's true. And, look, Don and Mike, I this issue about what to do about the internet, what to do about AI, what to do about TikTok, what to do about anonymous accounts, what to do about hate speech, what to do about the information stream in which we all swim. That's on, that's at the periphery of so many of the discussions we have here and so many of the discussions that are emerging around the country. It's inevitable that when a series of discussions takes place across the ideological spectrum, that Congress will get involved, that it will attempt to pass regulations, that it will attempt to engage in some sort of regulatory oversight. And it's at that point that litigation will develop around various ideas of limits on governmental power. In particular, First Amendment limits, like Mike and I have, Don have I don't want to say crossed swords, but we've approached the issue of what to do about social media and young people from differing perspectives. Mike's perspective is very much about protecting young minds, protecting health and creating healthy young people, and recognizing the corrosive impact that social media can have on them. I'm more of a First Amendment purist and view the family as the gatekeeper in that instance. I think Mike would respond by saying that's naive, if not criminally so, and perhaps even stupid. And I'm going off on my own, because families just can't be everywhere all the time. And don't we need, in some sense, some better protection of young people against the predatory instincts of large and big tech? And, Mike may be right, but I am still uncomfortable with giving the government a place under the tent in terms of regulating access to content, because the minute it gets its nose under the tent with kids, then it's going to go up to teenagers, and then it's going to be a short step from there to hate speech. And each step along that continuum, I think, is going to be litigated, and I think in perhaps necessarily so. I mean, if you look at TikTok, you know, and I know we're not going to spend a lot of time on this because other people are beating it to death apparently this morning. But you know, TikTok's glorification of Bin Laden's letter to America, you know, is an example of the harm that TikTok or that social media can do. You know, and so, you know, we've got hundreds of thousands of people reading this swill saying it opened their eyes and they now see America in a different light. You know, I wonder what they were looking at before. But I'm not so sure I want to limit their access to ideas. On the other hand, you know, I can imagine me in the emergence of the automobile with my, you know, reservations about the state. Do we really want the state placing an age, a limit on when people can drive? I mean, there are 12-year-olds who can drive and they can drive safely. But yet now we accept the notion that there's an age below which you shouldn't drive because people are generally too immature to do so. Maybe in the context of ideas, we're going to emerge at a similar place. Kicking and screaming all the way by people like me, and you can expect to see me in court fighting it along the way, but we may make a collective judgment that these things are necessary.
We do that out of what? It's in the interest of the public health, right?
Well, you know, again, regulating ideas in the interest of public health.
Having a license, right? So someone under 16 having a license, operating a motor vehicle on public roadways. That's what I'm saying. It's a public health objective, right? At bottom, and that's what I'm saying. I'm not talking about speech. I'm talking about what speech one is subjected to before one has an opportunity to even form thoughts about the world and oneself adequately. I'm talking about
maybe a distinction without difference.
I don't know. But anyway, this is a big deal. Dawn, thank you for putting this on our radar. And I really have no idea how this has gone. If this was being talked about at the end of October, this sort of digital equity, whatever. I feel like if I channel my inner Alex Jones, this is like, you know, Vivek is talking about the digital assets and cryptocurrency, stablecoin, etc. The West Virginia v. EPA and out of control regulators sort of making up rules as they go. And if I channel my inner Alex Jones, I kind of feel like if the Biden administration is going to attempt to take control of the internet in full, is this sort of the introduction of the Federal Reserve's digital dollar? Is this the stable coin that will be sort of the digital cryptocurrency and squashing out any other provider of cryptocurrency by top-down authoritarian means?
And thus politics, well, let me directly challenge my inner Alex Jones. Could this be an example of the deep state in collusion with the Chi-Coms and the globalists trying to impose global norms on all of us to the derogation of our individual liberties?
And they're voting on this when Xi comes to San Francisco. I mean, it's a little too convenient.
Yeah, no, I mean, look, in the end, it's funny, Mike, because in the end, every conversation about regulation really just comes down to a decision about what you think the role of government should be in our lives and what checks and balances government should have when we give it power. And so these questions always, in the United States at least, become legal questions and questions of constitutional law. Dawn, thank you for putting that on our radar. You know, somehow it had escaped me in my preoccupation with Palestine and the Middle East this last month. It is an important discussion, and it's one we will engage in further.
We Hear Well says, I don't understand Mike's point there, talking about, well, We Hear Well says, I'm with Norm 100 on this. I live in a country that thrives on censoring wrongthink, and it creates a culture of citizens policing citizens on behalf of the state. I don't understand Mike's point there. So I certainly understand that, and it's my problem that you don't understand my point. So We Hear Well. I trust that you do hear well, and I will work harder to make my point more.
Well, I think, Mike, it's, you know, this is one area where we disagree, and that it's fine to disagree. I mean, that's what makes the world work, and I'm glad we have one. And I think reasoning through our responses to this problem requires several steps. Recognizing what the problem is, seeing it accurately, not overestimating it or minimizing it, and then asking fundamental questions about what risks we're prepared to accept and tolerate, and what the role of government should be in managing those risks. And if we're to give government power, what checks, balances, and limits do we place on it, and how do we enforce those? If you listen to all those questions, that's constitutional law and administrative law writ large. And so, forget all this garbage about identity politics and colonial settlers and all this other jazz. When it comes to distribution of goods and services, the questions remain fundamental, and that is, what role should the government play in enforcing a vision of the common good? I tend toward libertarianism. I don't want people telling me what's in my own interest, and I don't want people protecting me from myself. There's only one of me, as near as I can tell. Oh, the little people.
This is what I think. This is what I intuitively understand about social media, is that it is an illusion of community. It's actually a completely fragmented society, and that the algorithms are such a black box, and the influence that these algorithms have en masse and at scale is widely unknown to the average person, idiots like you and me, Norm. Right?
It's true, and so we'll pay attention to it.
And so, from a public health perspective, from almost sort of a vaccine skeptic perspective, my issue with TikTok, my issue with Instagram and Facebook, etc., is simply that our young people, older people, take for granted a longer timeline of history and knowledge and context. Younger people don't have context; they don't have a timeline. When a young person begins to absorb current events, and current events are hyperbolized and propagandized in a way that makes them seem like the most important event in world history, right? Right now, Israel v. Palestine. Imagine 12 and 13 and 14-year-olds who are just now becoming aware of themselves and the world, and what impressions they are right now forming based on the arbitrage that these algorithms are able to manufacture into their timelines, what their view of the world is, based on what they are being told is important from a screen in their hand and in their pocket. To me, it's not a First Amendment issue. Maybe it is. Maybe it is a First Amendment issue. But maybe also you're not allowed to vote until you're 18, right? Maybe you're also not allowed to smoke cigarettes until you're 18. Maybe you're not allowed to buy a beer until you're 21.
So what, you're not going to think until you're 16?
No, I'm saying that you should be allowed to fully develop and make decisions about how, what information. I don't know if it's 16, but I'm saying that we can't pretend that you're going to tell a 10-year-old that certain groups of people all think a certain monolithic way, and they are certain types of evil, and that they're not going to grow up with some.
Here's where the rubber meets the road. I mean, you want to protect young people from indoctrination, undue indoctrination, and from the evils of ideas they may not be prepared to accept. Plenty of people think our schools are doing a pretty good job of that right now.
Right. And that's why I said that it's
so,
it's an illusion.
Whose responsibility is it to educate a child? It's the families.
It's the parents. It's the family. Correct. It's the community. And what I'm saying is that social media has given an illusion of community that does not exist.
Well, I don't. Or in the alternative, it's created a new type of community that we have to learn to exist in within an existing framework of constitutional metes and bounds. It can be both. So let's pivot out, because we're over time. Do we want to take a poke at Connecticut's public defenders today, or do we want to save it for next week?
I was going to say that, or we can spend maybe 5 or 10 minutes here with some AMA. I did promise some AMA, and the public defender.
Ask us anything. Go ahead.
Yeah, throw some questions into Rumble, throw questions into the YouTube chat, and we'll start taking a few of them. And while we do that, I'll read a few comments from over here on Rumble, and I'll see. Actually, I think I can pull in our sort of Rumble chat.
Here's a question I have for people. What the hell is wrong with the Focusrite product? That's why we've had some technological issues this week. I plug my headphones and my mic in, and it'll work for a while, then it stops working, and I don't know why. Anybody have an answer to that?
It may be fundamental compatibility with your here. Oh, look at that! Look at the Rumble chat. Here we go. Did Norm talk to Owen yet?
I'm going to talk to Owen this morning. We've had a lot of difficulty persuading the Bureau of Prisons that A, there is a Norm Pattis, that B, he is a lawyer, and that C, he represents Owen Schroyer. So after the better part of a week of exchanging documents, yesterday, shortly after appearing on InfoWars and criticizing everyone. Or no, I guess just about the time I did appear on InfoWars and criticize everyone. I'm told that this morning at 11 o'clock, I think it's Central Time, I don't know if it's Central or Eastern Time, Owen will be able to make a legal call to me. So I'm hoping to speak to him today.
Cool deal. Let's see. In the Cloud is suggesting that maybe you need an update to your device driver. What it felt like to me, Norm, was that I could hear something occur and then the sound would go out. So I don't know if it's something to do on the hardware.
Well, I talked to the folks at Sam Ash last night and explained what was going on. They said this should do it. So let you and I stay on a few minutes later. We apologize to everyone for these technical difficulties. So we'll just blame the deep state.
Well, look, it's part of our brand for the time being, and it's okay. Everybody loves us anyway. Lawyer Will says, wondered if Norm could weigh in on Shkreli's comment that the government has a big advantage by going first in a criminal case. He talked about the psychological aspect of framing, and when he's talking about Martin Shkreli, he's talking about his appearance on Tucker Carlson, I think last week, maybe the week before, where the government does have a huge advantage by going first in the criminal cases.
Well, I don't know how else they would. Because the government, every conflict in a courtroom is adversarial in nature, and it takes a party to pick the fight. So, in a criminal prosecution, it's the government's burden of proving its case, and it brings the case, and it does set forth its theory of the case in its charging documents, either an indictment or an information, and that does frame the issues. The defense's responsibility at that point is to meet the defense, and it has a powerful set of constitutional tools to do so, including the presumption of innocence. But once you're charged by the government, you're guilty in the minds of many, and thus the need for defendants to take their case to the press, in my view, especially in a high-profile case. That's what's so damaging about gag orders. Like, for example, in the Alex Jones case, anything happens in that case, it's national news. And so is Jones supposed to sit back and say, oh, I'll save my talking in court? No, it seems to me that once the government and or a plaintiff frames an issue and puts it out into the public, the defense has a right to defend in equal terms, even to up the ante if they care to.
Understood. Lawyer Will, I'm not sure if that answers your question in full, but I think
I missed the Shkreli interview, so I missed the context. There may be a lot more to it than that, and I'm happy to follow
up. So Jackson Barrett asks, how would Owen know what mail he is not being permitted to receive? That's a great question. He wouldn't.
He wouldn't, yeah. I do know that when Owen spent a week in COVID lockdown when he first arrived at Oakdale, and I know that he received a lot of mail then, because when we talked, he talked about how meaningful getting the mail was. I'm aware anecdotally from emails and the social media that many people have sent Owen material, including postcards, benign postcards, and they've been returned as undeliverable. So it's possible that Owen has received nothing in the last 2.5 weeks. I did write him a letter that was marked attorney-client communications and was consistent with the protocols for writing to an inmate in an institution and having that letter get to him unopened. I'll be curious today to find out whether he got that. But Jackson Barrett, it is entirely possible that Owen has not had any communication with the external world at all.
We Hear Well says, Robert Barnes always says the court of public opinion is critical, so it's incumbent on defense attorneys to advocate both in the courtroom and on social media. I think this is something, Norm, that you and I have talked about, in particular with the leak of the proffer videos in the Georgia case with Jenna Ellis and the other, I guess, pleading co-defendants. And initially, my thought was that was some sort of technique to, because of the way that the internet search results, whenever you put in Jenna Ellis testimony leak video, it was all of the major media establishment players reporting on it, but they were reporting on it in a way that appeared favorable to the prosecution, right? But what came out later in the week, I guess yesterday, the day before, is that the leak was actually at the hands of one of the other co-defendants' defense attorneys, not named Trump, right? And did that for reasons that I think We Hear Well, you just sort of said, is that he didn't want the public to be misled about the nature of those videos. So ethical quandary aside, I think that there is an inherent recognition that there are two courts and two proceedings at play in many of the high profile cases in this day and age. And one is it seeks to leverage the virality or the potential thereof of the internet.
Yeah, as to Barnes's comment, I mean, Rob, there are things known. There are public intellectuals and there are public lawyers. Bob views himself as a public lawyer who gets involved in cases that advance the public interest, and so I think from his perspective, talking about his cases or other cases that invoke the public interest is critical to educating the public. That's fine. I get that. But I think a lawyer's primary responsibility is to his client or her client, and a co-equal responsibility is to the court. And thus, following the rules of court are important. And there are occasions where pretrial publicity can be prejudicial. Now, I can't remember if it's Rule 3.6 of the Model Rules of Professional Conduct, but there's a lively debate that's gone all the way up to the United States Supreme Court about what you can and cannot do in a high-profile case. So, in most cases, my office right now has about 100 active cases of one sort or another, ranging from DUIs to murder, ranging from First Amendment cases to that everybody talks about to cases that nobody cares about, never heard about, and they don't want to hear about other than the parties involved. But in a high-profile case, when the government attacks, I think the defense has an obligation to counterattack on behalf of their client, and the rules of professional conduct recognize that. So there's a famous United States Supreme Court case, I think it was decided in the 70s or 80s, called Gentile versus Nevada Bar Association. And in that case, the state of Nevada got an indictment, a criminal indictment against a man, and Gentile's lawyer went after, I think Gentile was the lawyer, went after the government's witnesses and went after the government's case and the bases of the indictment. And Nevada Bar Association officials cited him for violating the rule of professional conduct, for engaging in extrajudicial, that is out-of-court pretrial publicity that was likely to influence the jury. And Gentile's position said, no, it's not. It's remote in time. That didn't satisfy them. He was disciplined. He took it up to the Supreme Court, and the Supreme Court held that the rule was sufficiently vague that Gentile should not have been punished. That there was arguments that he should make, that he was right, and therefore, because the rule was vague and his conduct was not indisputably wrong, disciplining him violated his right to due process. These gag order cases involving Trump are a great illustration of this principle of law at work. And the problem of framing. I mean, Letitia James, can hold a press conference and can malign Trump's motives and can talk about how she's going to take him down. And then Donald strikes back, questioning her integrity and the integrity of the process. And that's wrong. It seems to me you fight fire with fire. And the First Amendment protects the government's right to speak. It also protects the individual's right to speak and to strike back, in my view.
So two stories that we didn't get to today. One was the news out of the Connecticut Public Defender's Office, where their director of diversity, equity, and inclusion has been suspended for a certain post that he published on Facebook. And the other was related to the Israel-Palestine protest, where a elderly Jewish man was killed. And the allegations are that that he sustained a hit to the head from a microphone, or a megaphone rather.
Killed by a college professor. Yeah.
And there's been an arrest made and an involuntary manslaughter charge. So that's a tease for, I guess, Monday. I definitely want to talk about the latter story, Norm, if for nothing else, but for you to have the floor to discuss the elements of involuntary manslaughter. We can just go by sort of a federal standard, and in particular to understand what that implies about one's mental state, what an involuntary manslaughter charge really means, and what that perhaps mean from the prosecuting authorities' perspective on the case. That is, this occurred in Los Angeles. We understand that LA is a very liberal location in the United States, deep blue location. And perhaps if this behavior were to have occurred on the facts that we know right now, we don't have all the facts. We don't even necessarily know if it was necessarily a hit with a megaphone. However, These are the allegations that have been set forth, and authorities are being very limited with what they disclose. But what I'm attempting to get to here is, could this have been undercharged? Right? That's the question. Is based on what we know and what we expect, is an involuntary manslaughter charge sufficient to remedy what we as a society would obviously agree is a wrong if the proof is made?
Well, I mean, the obvious question that comes to mind is, had he been a BLM protester, would it have been murder? And the megaphone was in the hands of a white cop. But is the fact that he's Jewish and protesting on behalf of Israel likely to yield to minimal charges? I've got my suspicions. Let's talk about that next week.
We certainly will. We'll go through the facts there, and then I definitely want to talk about the director of diversity, equity, and inclusion. I'm a Connecticut resident, so I was in Bridgeport court the other day. And Bridgeport's the state's largest city. And we were in chambers and there were a bunch of us talking about cases. It felt like a depression clinic. And then I realized that's because most of the lawyers in here are public defenders. And the institution they work for is becoming such a shit box that it's a wonder that anybody comes to work in the morning. So let's talk about that next week. 100%. Norm, thank you for everything this week. Thank you, everybody on Rumble and on YouTube and over on X at LawPod Daily. Please be sure you're following us. If you can enable notifications, do that. Make sure you know when we go live. Norm and I are going to spend some time working on the technical background so we ensure that we can have more technical difficulties in the future, because it is so fused with our brand now that if we stop doing that, you guys would probably label us as being inauthentic or selling out. And we don't want that, Norm. We don't.
No. Listen, I got this podcast you should listen to in the morning. It's called Law and Legitimacy. They fade in and out. And there's this old guy who couldn't find his ass with both hands. And he thinks the crack there is a mistake of design. And he keeps trying to get it sewn up. And there's this young guy, smart guy, puts up with him. I don't know why he hangs around with the two, but it's like watching Laurel and Hardy. I mean, you never know what's going to happen. And what's more, this old guy, he'll get going on a roll and then the microphone will cut out. He'll come back and he'll pick up where he left off, but he never quite finds the same thing. It's really confusing. You've got to listen.
70% of our audience just thought that your mic went out again. That's how believable that was. That was excellent. Dawn says, R.I.P. Joe Burrow. I don't want to talk about it. See you next week, everybody. See you, Norm.
But go blue, go blue, go blue.
Oh.
You can take the harbor.